All right, welcome class. This is another one of the short lecture videos going to discuss the concepts in the business law course. And in this first video is a little bit of an introduction and also a discussion of the primary sources of law. As you know from these videos, I am trying to keep these videos to 15 minutes or shorter. So they're quick little videos that you can watch and to help you kind of work your way through the material in the Canvas course and in the textbook. So, by way of introduction, and as you start to kind of go through your study of law and business law, and particularly this course, is this kind of just concept of why does our society have laws? And as I do the videos, you can just follow along on these outlines, and I'll kind of scroll through. And this is the outlines that I have posted on Canvas as well for your class. So, why do we study law? The most important function of law in our society is to provide this stability and predictability and continuity, so that people can be assured of order in their personal affairs and business affairs. This is kind of a fancy way of saying, when you think about it, laws really create rights and obligations between individuals. We have criminal law, where we provide what is legally right and what is legally wrong as it relates to crimes, meaning that the punishment for violating a criminal law would be to pay a fine and go to jail. On the civil side, we provide remedies for civil wrongs. Now, criminal wrongs and civil wrongs the same act can create liability in both a civil court and a criminal court. But as I mentioned, on the criminal side, the punishment would be a loss of your freedom, meaning you could go to jail or prison. On the civil side, you would be provided with the opportunity to seek redress in a court and get a civil remedy by way of monetary damages or by way of a court order for someone to do or not do something. So it provides those sanctions for wrongful acts committed by people, and it also provides a means to seek redress for wrongs that cause civil damage, right? So we might seek monetary damages, money, or a district attorney's office, or the state prosecutors, or at the federal level might prosecute an individual for conduct that's criminal in nature, with the outcome of perhaps putting that person in jail. By general definition, laws consists of rules, enforceable rules that govern relationships among individuals and between individuals in our society. Again, they create rights, duties, privileges that are consistent with the values and beliefs of a society. This concept of jurisprudence, you might hear this term jurisprudence, and this is by definition just the science or philosophy of law. And so sometimes you might hear me say in American jurisprudence, I'm just talking about this concept, this philosophy of law that we're discussing in this course. So we just to recap, why do we have laws in our society and why do we study them? Because they provide stability, predictability, and continuity in our affairs and actions as we go through society and we interact with other people in society. And we'll talk a little bit more about this as we kind of go through the course. Obviously, when we talk about torts, which is a body of law for civil wrongs, we talk about criminal law, we talk about contracts, we talk about corporations and that kind of thing. This is all this area of law that we're going to study that apply to transactions and relationships in society when we interact with each other, and we might cause damage or we might enter into agreements with each other. This is the type of things that we'll be studying in this course. So before we move forward in the course, we have to talk about where our laws come from. So we kind of talked a little bit about why we have laws, and now we're going to discuss where these sources of law come from. we talk about sources as primary, and either primary sources of law or secondary sources of law. And so primary sources of law consists of the United States Constitution and the Constitution of the various states, statutes or laws passed by Congress, or for that matter, any legislative body at the state level or the federal level, right? So we can have big C Congress, and we also have state legislators, and we elect them, and they go to the body in which we've elected them, either Congress, the Senate, either at the state level or at the federal level. And really what we're asking them to do is take a look at how society is functioning and whether they need to enact laws or not. That would be statutory laws created by Congress or legislative bodies. We also have regulations created by administrative agencies, and we have case law, and those are the primary sources of law. And I'm going to talk about each one here as we go through this discussion. And then secondary sources of law are books, articles, treaties that summarize and clarify the law. Your textbook is a secondary source of law. This is not a primary source of law. Primary sources of law where you go and you say, okay, this statute says, right? This statute says X, and we read it and we go, okay, here's the statute. Or we go to the Constitution. We say our right is guaranteed to be free from unreasonable searches and seizures by the Fourth Amendment to the U.S. Constitution. So we would actually cite the actual U.S. Constitution. That's a primary source of law. Where your book summarizes the law, this is not something you would cite in court or use as a legal argument. So first and foremost at the top of the list is this concept of constitutional law. And as I said previously, the federal government and the states have written constitutions, both at the federal level and at the state level, that set forth the general organizational powers and limits of their respective governments. Constitutional law, both at the federal and state level, deals with the fundamental principles by which the government exercises its authority. And so when we look at constitutional law, we're really looking for inherent rights that have been established, like the Bill of Rights in the U.S. Constitution. And then we're also looking at other organizational powers that the federal government has, and then those powers that have been left to the states. And so we will take a look at the Bill of Rights in another video, but for now, just summarizing this concept of constitutional law. The U.S. Constitution, in Article 6 of the U.S. Constitution, establishes that the U.S. Constitution is the supreme law of the land. As such, it is the basis for all law in the United States. Laws in violation, laws cannot be created in violation of the U.S. Constitution. They would be declared unconstitutional and would not be enforced. That being said, when the U.S. Constitution was drafted, there was really this kind of concept that there was going to be a lot of power left to the states. And we'll talk about this more in another video, but for now, understand that the 10th Amendment to the U.S. Constitution reserved to the states all powers not granted to the federal government under the U.S. Constitution. So the idea behind the Constitution is that it's enumerated, spelled out, numbered rights. These rights are stated in the Constitution, and those things that are not stated in the Constitution that give the federal government the power then goes to the states through the 10th Amendment, meaning that the states retained a lot of power. In another video, I'll talk about the Commerce Clause in the 10th Amendment and the interaction of federal and the conflict between federal and state laws in the future video under federal versus state powers and the Commerce Clause. Statutory law, as I said, is a body of law that's enacted by legislative bodies at any level of government. This, we're in California, so our state legislature enact laws during every session. At the federal level, Congress, Big C Congress, enacts laws as well. And we can look for and find those laws in statutes or our code books. And they're actually, so the statutory law is written, and then it's usually put into a different code book. And so we can look it up and find the various laws that are created both at the federal level and at the state level. The citation, generally speaking, when we look at laws, there's going to be in the textbook, sometimes in other kind of referenced analyses of laws. Usually there'll be a citation to the statute and how we can find the statute. Now with the internet, you can look up statutory law quite frequently. If you wanted to look up, say, California contract law or something, you can kind of do a broad search on the internet and find a lot of stuff. And you can also look stuff up, other things like the penal code or criminal code. And I'm trying to talk, I know I'm talking a little bit quick, just trying to get through this 15 minutes. Federal statutes, as I said, are also created at the federal level. We'll talk a little bit more about uniform laws as we get into contracts. Administrative law is an interesting one. Administrative law is created from administrative agencies, and administrative agencies are agencies created by enabling legislation, as you can see here, that's created in the actual statute. So if the federal or state government creates a statute, a body of law, then a lot of times they're then going to also create an administrative agency that would perform the specific function of carrying out the law that they've created. This is called enabling statutes, enabling legislation that allows the federal government, state governments to create agencies, and those agencies then also have the power to make rules and regulations. And so a body of law known as administrative law is created. Finally, we have case law and common law doctrines as primary sources of law. And case law is the body of law of doctrines around actual cases. And so as a case kind of moves through the system, there will be a decision that's rendered on that case. And once that decision is rendered by a court, either an appellate court of the state or the state Supreme Court, or sometimes the appellate court of one of the appellate courts at the federal level, or the United States Supreme Court, then there will be a decision rendered on that case, and we can look to that decision and read the decision, which is going to help us interpret the law that was associated with that particular case, whether it be a constitutional law or statutory law, and it helps us understand case law. And sometimes courts will either expand or clarify statutes or constitutional provisions, which also falls under this body of law known as case law. So in the last couple minutes here, I'll just mention that this is case law and common law. The term gets thrown around together, but when we talk about common law, this was this concept from early English courts, and much of our American legal system jurisprudence was taken from English legal system, and which kind of started this concept of common law, when we started American jurisprudence, we pulled a lot of those common law principles out and brought them to our American system of jurisprudence. So I hope you enjoyed this video, and if you have any questions, please feel free to reach out to me, and I will continue to do these short 15-minute lecture videos and try not to put too much information in one video, and let us chat a little bit more. I might extend the length, but for now I'm trying to keep them to 15 minutes or under. So feel free to reach out if you have questions about this primary sources of law.